versus Alyssa Kenberg.
For the record, this matter is before the court for a continued pretrial conference subsequent to mediation. This hearing is being conducted via Zoom. It appears both parties are present. The plaintiff, Ian Kenneberg, and the defendant, Alyssa Kenneberg, and also present is Ms. Stephanie LaPrade for the Monroe County Firm of the Court. Ms. Kenneberg, good morning. Ms. Kenneberg, you need to unmute yourself. Good morning.
Good morning.
Mr. Kenneberg, can you hear the court?
Yes, I can.
Okay. Oh, it's like a wave. Right, the court's in receipt of a judgment divorce. The two of you have signed, but and the court's being very confusing. The last thing we want you to do is come back to court because we have misunderstandings. But the two of you do have an agreement. Perhaps we can clarify that on the record.
I do.
Yes, sir.
Ms. Kenneberg?
Yes, sir.
Miss Alyssa Kenneberg?
I said yes.
Okay, I'm sorry. Did not hear you. Need to speak up? I'm sorry, I didn't hear you. All right, we'll start with you, Mr. Kenneberg, since you're the plaintiff. Can you please state your name and current address for the record, sir?
Ian Kenneberg.
Thank you. Mr. Kenneberg, is it true that you filed a complaint for divorce with this court?
Yes,
On
sir.
about November 2nd, 2023.
Yes, sir.
Is it further true that on the date you filed the complaint that you'd reside in the county of Monroe at least 10 days, the state of Michigan at least 6 months?
Yes, sir.
Is it further true that you married Alyssa Smith, now known as Kenneberg, on July 20th, 2018? You separated in August of 2022.
Yes, sir.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable chance of reconciliation?
Yes, sir.
Were there any children born or adopted during your marriage?
No, sir.
And you signed your name to this proposed judgment approving the terms and conditions contained therein. Is that correct?
Yes, sir.
All right, thank you. Ms. Kenneberg, can you please state your name and address for the record?
Alyssa
Ms.
Kenneberg.
Kenneberg, did you hear the testimony this morning of your husband, Ian?
Yes.
Was his testimony true and accurate to the best of your knowledge?
Yes.
Are you currently pregnant?
No.
Did you also sign your name to this proposed judgment approving the terms and conditions contained therein?
Yes, sir.
Okay, so I'm going to walk through the terms of this judgment with you so we can clarify the record exactly what the intent is. And if we need to make some modifications, we can do that. You've agreed that spousal support alimony is not awarded. That's forever barred. It says personal property is divided according to the attached personal property debt addendum. You've attached a 2-page addendum. You can tell the personal property debt addendum. And yes, you list assets on one side, liabilities on the other, but it doesn't say who is being awarded those assets. For example, the home, you've already sold the home, so there's no real estate, correct? You just have the proceeds from the sale of your home. Okay, so you've got a Jeep. Who is the Jeep awarded to?
That's mine.
Ian.
Okay, okay, is that, it's not real clear from this document. Is that Jeep titled in your name, Mr. Kenneberg?
Yes, sir.
Okay, it says $825. Is that the remaining debt on the Jeep?
That's the value of it. The gas value of it. It does not barely run.
Okay, so what's the significance of the $825 figure?
That was just putting down the amount of what the car value is worth. Same with the Focus, the same with the assets of the furniture was how much we sat down and divvied out and figured out how much all of those items were worth.
I'm sorry, you said a Focus? Is there another automobile involved?
That is.
Oh
mine.
no, we took that off, right?
The Focus you take off?
Yeah, I thought I took it off. I thought we agreed to take it off, right?
Yes.
There's no
Okay, so it
reference
should
to
just be
Focus on these documents. That's why it's very confusing.
Your Honor, if I could be of help, I had the same issue. There's some dark lines on my copy, but their names are listed in there. It's got Ian first, and then it's got Alyssa underneath, and they've divided out their debts and their assets on the spreadsheets. It's just hard to see because it's highlighted.
Okay, so maybe explain it to the court. It says, yes, under the highlighted section where it says Ian Kenneberg, 50% assets, 50% liabilities, it says sell the home, $15,428, that's the amount that's going to Mr. Kettenberg?
15, that was,
Mr. Pratt, can you explain it to me?
Yeah,
Do you
yes, sir.
understand the judgment, Mr. Pratt?
I do,
Yeah, the court
after
does not.
speaking with them. So the parties used the sale of the home to pay off debt, and that's where the sale of the home money went to. They are also using half of their retirement to pay off the other portion of the debt, so they're not going to have debt. So the assets are split between the two of them. The debts were technically split between the two of them, but the way it's written is they wrote that so that they know that all their debts are taken care of with the mortgage or the payoff from the home and his 401k half that would have gone to Alyssa. And that's how they've managed to pay off their debt, and they've split their assets. So that's how that spreadsheet worked after my conversation with the parties.
Okay, I see the sale of the home referenced three times, and I have three different figures.
So the first one is just your combined. The second one is it split between the parties, the second and third, Your Honor.
Oh, I see, okay. So the proceeds from the sale of the home are $33,631, and 15,000 of that, 15,428 will go to Ian, and 18,203 to Alyssa. Is that correct?
Yes, sir. That's how they have it split on their balance sheets.
Okay, the Jeep will go to Ian. The furniture will go to Ian, and this retirement of it says $4,409.95.
That's them splitting Ian's retirement, Your Honor. And that's how they balanced it, was Ian was taking so much and Alyssa was taking so much. But again, Alyssa's portion being put towards that joint marital debt.
Is that correct, Mr. Kettenberg?
yes, sir.
Okay, so you've already secured that loan from retirement. Is that correct? That's already been pulled out?
No, sir. I didn't know if I should do that after we had this conversation today or not. I just didn't know.
Now, what about will there be a penalty when you withdraw that?
Say that again.
Will there be a penalty for early withdrawal of that sum from your retirement?
I have before, and there was before. So yes, I would say that there is a penalty for it, but I was willing to accept that.
Okay, so you'll be responsible for any penalty then, correct?
Yes, sir.
So how much will you withdraw from your retirement? $4,409.95 to pay to Alyssa?
Yeah.
Right.
Well, yeah, to put towards our debt. Yes, the 4,000.
And of course, you've listed a lot of debts and liabilities. That's fine. That's all going to be paid.
Mm-hmm.
The sale of the home proceeds and the retirement, correct?
Yes.
You agree, Ms. Kettenberg?
Yes.
Mr. Pratt, perhaps you understand this better than the court does. Do you have any questions that you think need to be asked of these parties on the record to clarify the terms of this judgment?
Your Honor, I think the only thing we would need is to set a deadline of how long it's going to take Mr. Kettenberg to get that money out of his 401k, because I think that's the only loose end. So I think just maybe clarifying that he's going to apply for that loan out of that 401k, maybe within 7 days.
Hold on, Ms. Kettenberg, you spoke over Mr. Pratt.
I'm sorry. I'm at work. I was not aware we were doing this early, so I'm on the clock. I have patients coming up asking me stuff right now.
Hold on, this was scheduled for mediation at 8:30 this morning with the
Your
pre-trial
Honor,
to follow at 10:30.
I was told we didn't have to do it.
It was scheduled for 8:30. Ms. Kettenberg called and notified me that she had a consent judgment that was turned into your office. So until I found out this morning from you that we needed to go through it, they were not planning to come in because they had the judgment.
Okay. But it's very important we clarify the terms of this judgment, Ms. Kettenberg, on the record. So there's
Okay,
not
and
any disputes.
that's perfectly fine. But all I was saying is I called, I did my portion. I was told we didn't have to meet at 8:30. I was told we were meeting at 10:30.
Do you want to reschedule, Ms. Kettenberg? We can reschedule. Do you want to reschedule to tomorrow?
I'm already here. I'm doing it. I can't take tomorrow off work. I'm just saying I can't ignore a patient who's trying to get directions.
Okay, do you
right
need
now.
to, we can recess for 15 minutes. You need to see, attend to a patient?
Yeah, can I just have like 10 minutes, please?
Okay, do you want to zoom back in, what, 9:30?
Yes, please.
All right, Mr. Kenberg, can you be about 9:30?
Yep, that's fine.
All right, we can recess. I'll just dial back in at 9:30 then.
Okay, thank you.
Mr. Kenberg, when can you pull out this money?
I could do it today, or I could call and start doing it today. I have no issue with that. I just have to call
Okay.
my 401k account.
Okay, I can write some language in this judgment, but we'll see you back at 9:30 then.
Okay, thank you.
Okay, thank you.
To enter a proposed consent judgment divorce, both parties are present for the Zoom hearing. And Ms. Kenberg, do we have are things okay right now?
Yep, I went home.
Okay. It shouldn't have taken much longer. I just want to make sure that everyone is on the same page and that we're all clear in the terms of this judgment. So you have the checks from the represent the proceeds from the sale of the home. You will, upon enter this judgment divorce today, you'll immediately start to pay off these debts with that $33,000 that you're holding. Is that correct?
Yeah, I have already been paying off all the debt with home, like the house money.
Okay. All right, good. And then you're awarded the Focus. Mr. Kenberg is awarded the Jeep. Your furniture you've already divided. Mr. Kenberg, I've written one sentence in your judgment. It says that the plaintiff, which is Ian, shall forthwith request withdrawal from his 401k to satisfy liabilities. I've initialed that. Is that agreeable?
Yes, sir.
Yes.
The total amount you're going to withdraw, Mr. Kenberg, is $8,819.89. Is that correct?
For the retirement?
How much are you going to withdraw from your 401k? The 8,000 or only half of that?
Half of that, the 4,000.
Okay, I'll clarify this. And so you're going to withdraw from your 401k $4,409.95, and with that, you're going to pay off these liabilities, correct?
Yes, sir.
All right, I will clarify that. So, all right, Mr. Kenberg, do you have any questions for the court?
No, I'm good to go, sir. Thank you, though.
So make that phone call, make the written application. What do you have to do to withdraw that as soon as possible? Ms. Kenberg, do you have any questions for the court?
No.
Okay, Ms. Kenberg.
Or actually, yes, I do. I just want to make sure that my name's going back to my maiden name.
Yes, and I was just going to explain to you, when you get a copy of this judgment, you need to take a copy of this to Secretary of State and Social Security to facilitate that legal change of your last name.
Okay.
The judgment does provide that your name shall be restored to Alyssa Smith. First of all, the court appreciates both of you appearing today. Based on anything else, Mr. Pratt, that you believe needs to be clarified?
No, sir.
All right, thank you for your assistance and talk with parties this morning and clarifying this, explaining to the court. Based on the testimony that's been presented this morning, as well as plain file this matter, the court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it's ordered by this court that the marriage between the parties be dissolved and judgment shall enter granting a divorce from bonds of matrimony. That will conclude, sir. You can both zoom out. I appreciate your patience, Ms. Kenberg, this morning. The court will sign the judgment. We both know a copy of this. And good luck to both of you.
Okay. Thank you so much.
Thanks, sir.
You're welcome. This matter is before the court at the request of the plaintiff, Patrick Henderson, and his attorney, Matthew Viddo, to place the terms of a proposed agreement on the record. This hearing is being conducted via Zoom. Present is attorney Matthew Viddo, representing the plaintiff, Patrick Henderson. Mr. Henderson appears to be present. Also, the defendant, Diana Henderson, appears to be present. Good morning, everyone.
Good morning.
Court notes that this matter is scheduled for trial on April 25. If in fact the parties have an agreement today, then that trial date will be vacated. Do you understand, Ms. Henderson?
Yes.
Yes.
Okay. All right, Mr. Viddo, If the court recalls, the primary issue was personal property divisions, automobiles, correct?
Yes, Your Honor. I think this judgment, it resolves everything presently before the court.
Okay. Has Ms. Henderson actually approved a judgment?
She has. I have an e-signed copy. I believe a copy may have been dropped by your office. If not, then I can make sure you have a copy of it today. But both parties e-signed it. I had the signature log, and we're ready to go.
Okay. The court has not seen the judgment. I don't know if it's in the clerk's office. Do you know, was that delivered directly to the court or was it delivered to the clerk?
It should have been delivered to your chambers, Your Honor.
Okay.
If it was not, then I apologize. I'll make sure that a copy is taken to the court today. I can put the material terms on the record.
Please. Yes, the court's not received that. So yes, if you could find where that's situated, you deliver that to the court so the court can have that today. But Mr. Vidal, please be placed on the record what you understand to be parties to full agreement.
Absolutely, Your Honor. So the judgment of divorce has the standard terms regarding the breakdown of the marital relationship and the object of matrimony being destroyed. The parties have no minor children together. It's a short-term marriage. In this judgment, neither party is being awarded spousal support, and they're waiving all future spousal support in accordance with Staple v. Staple. Has a standard statutory insurance provision notifying the parties that they have to change their beneficiaries on their own. Has a clause in there saying that each party can obtain COBRA insurance coverage if available and at their own expense. Says that each party is going to keep their own pension or 401k retirement plan free and clear of any interest of the other. Neither party owns or has any interest in any real estate, so there's a clause in there just noting that. It also says the parties are awarded the personal property in his or her possession, as well as their own individual bank or financial accounts and any funds therein. And they're going to assume and pay any debt owing on any personal property retained by him or her. Plaintiff is specifically awarded all disability payments and other benefits through the Veterans Administration, whether connected to his military service or otherwise. He's receiving a 2006 Ford Aerostar that's red in color. Defendant is being awarded all her personal belongings, any tools of her trade, furniture, appliances, and the like. A 2000 GMC pickup that's reddish brown in color. A 2014 Cadillac SRX4 that's dark gray in color. And obviously, as I said before, both are receiving their own bank accounts and financial accounts. Marital debts, they have no joint debt. So it's my understanding that Ms. Henderson has some student loans she's keeping and assuming those. They're going to file their 2023 taxes, married filing separately, and they're going to keep whatever refund or liability that they have on their own filing. Ms. Henderson's former name is being restored to her of Davies. The party's going to pay his or her own attorney's fees. And it has, they're each waiving any discovery, trial, and whatnot. And that's the complete judgment, Your Honor.
Thank you. Mr. Vidal, thank you. With respect to the two automobiles, we have a GM pickup and a Cadillac. Who was awarded which vehicle?
So there's three vehicles. There's a Ford Aerostar, there is a pickup, and there is a Cadillac. And the pickup and the Cadillac are being awarded to Ms. Henderson, and the Aerostar is being awarded to my client.
And there's no indebtedness on those vehicles, is that correct?
I believe that there is none regarding any of the vehicles. They're all owned free and clear.
Thank you, Mr. Vidal. Ms. Henderson, did
Yes.
Mr. Vidal accurately state your agreement?
Yes, Your Honor.
Thank you. Mr. Vidal, we did take the proofs back on February 29th, 2024, but the court will simply update those for Ms. Henderson. She's not currently pregnant. But if you want to word to Mr. Henderson regarding the terms of this agreement, please.
Yes, Your Honor. Thank you. Mr. Henderson, you've heard the terms of the agreement that were placed on the record.
Yes, I have.
That's your agreement, right?
Correct.
No one has pressured you or, threatened you or anything to get you to enter into this agreement?
No, sir.
Do you believe that it's a fair agreement?
Yes, sir.
I know that there was other proposed judgments that we had provided to Ms. Henderson. And this is ultimately the terms that are in this judgment are the ones that you wanted me to put in there. Is that right?
Correct.
All right. And part of that addition of other information or other, I guess, bargains into this judgment was because you didn't want to go to trial on this matter, right?
Yeah. I've had over.
And you understand that when this judgment is entered by the court, any right to a trial is waived, right?
Yes.
Okay, and we did participate in discovery in this. We did send discovery requests to Ms. Henderson, right?
Yes.
Okay, and she did not answer that discovery, but when this judgment is signed by the court, all discovery is waived too, right?
Right.
Part of this agreement involves the waiver of spousal support. You understand that applies to both you and her.
Yes.
So, and this, once this judgment is signed, neither you nor her can come back to the court at a later time and ask the court to grant any kind of spousal support.
That's correct.
It's forever barred.
Yes.
Okay. Now on this, you signed it electronically, right?
Yes, sir.
And you also initialed each page of the judgment, correct?
Yes, sir.
Okay, and you want the court to grant this judgment?
Yes, sir.
I have no further questions, Your Honor.
Thank you, Mr. Vido. Ms. Henderson, could you please state your name and current mailing address for the record?
Diana Henderson.
Thank you. Ms. Henderson, did you hear the testimony of your husband, Patrick, this morning?
Yes, I did.
Is this testimony true and accurate to the best of your knowledge?
Yes.
Are you currently pregnant?
No.
Is it true that you have approved with the e-signature the proposed judgment of divorce prepared by Mr. Vido?
Yes, Your Honor.
And you're asking the court to enter that judgment today, is that correct?
Correct.
Do you understand that there will be no trial, and that the trial scheduled for April 25 will be canceled and vacated?
Yes.
Do you have any questions for the court?
No.
Do you have any questions for Mr. Vido?
Yes, one. Mr. Vido, we discussed about having the record sealed, and you were going to bring that up.
Yes, Your Honor. Ms. Henderson had asked, there are certain items in the request to admit that she finds potentially embarrassing, and she did not respond to that. And she wanted me to ask the court whether or not the court would seal the request to admit. I told her that it's entirely up to you, but that I would make that request.
I'm sorry. You filed a request for admissions back in January, is that correct?
Yes, Your Honor.
And you're asking that those requests be removed from the court file and sealed by the clerk?
That's what Ms. Henderson is asking.
Excuse me, Your Honor. They're all lies. Utter lies. Mr. Henderson has done nothing but play games with courts, getting PPOs that aren't even warranted. He makes up lies about this, and all these lies are out there about me now. And I would like to where people can't read these about me because he wants to put these lies out there.
But this is not an electronic file. Someone's got to actually come into the courthouse physically to look at it, and there's no admissions. There's just an allegation, Ms. Henderson. The court sees no reason to seal this, and there's no legal basis.
Okay, that is fine if they're just allegations and they're not. I mean, because he puts them out there and they're all lies. and I'm just sick of it. I'm sorry, Your Honor. I'm just glad I'm getting rid of this narcissist.
Okay, it's noted for the record, your position
Okay.
that they're all lies, Ms. Henderson, but the court doesn't see any basis to seal these pleadings in this file.
No,
They've not been responded to.
Shut up. Sorry,
I'm sorry?
Your Honor. No, nothing, Your Honor. I was not speaking to you. I'm sorry.
she's being.
I was talking. I was
Mr.
talking
Henderson,
to the
please be
dog.
quiet.
Please mute. Let's mute Ms.
Excuse me.
Henderson.
I
Ms.
was
Henderson, can you
talking to the
please?
dog that
Ms. Henderson, please, both of you stop.
Shut
Both
up.
of you stop. You're
I
adults.
was just
Come on.
okay, Miss Your Honor. I was just talking to the dog that keeps barking. I'm sorry.
Okay. Do you both want to get divorced today?
Yes, I do, definitely.
Okay.
Right.
One last question, Ms. Henderson. Last time you were in court, you were on pain medications. You were in a neck brace today.
Yes.
Are you under the influence of any medication that could impair your judgment to make a decision?
Not now, Your Honor.
All right.
I'm off them.
Mr. Vindo, do you have any questions of Ms. Henderson?
Just one, Your Honor. Ms. Henderson, have you disclosed all your assets to me during this proceeding?
All I have is Social Security. So
Okay, but you've hidden nothing?
no, nothing.
I have no further questions, Your Honor.
All right, thank you, Mr. Vindo. The court would like to thank and acknowledge Mr. Vindo for his assistance in helping to facilitate a resolution. Mr. Henderson, without question, the best resolution is one which the two of you reach and settle rather than have throwing things up in the air and have the court decide these matters. Maybe the value of a motor vehicle is not great enough to incur the aggravation of a trial.
Absolutely, Your Honor.
So you made the right decision. You were well guided by Mr. Vidido. I know that it's been frustrating because we have pleadings that were not answered by Ms. Henderson, but she's representing herself and it makes it more difficult. So the court appreciates your efforts, Mr. Vidido. If you get the judgment to the court today, we sign that. Ms. Henderson, when you get the judgment, you want to take a copy to the Secretary of State and Social Security to facilitate the legal change for the last name. So don't forget to do that, okay?
Okay.
Again, with this agreement of the record, the court will cancel and vacate the trial scheduled for April 25 at 8:30. Based upon the testimony that's been presented today as well as previously, the court finds that jurisdiction has been established and that there has been a breakdown in the marriage relationship to the extent that the object of matrimony has been destroyed and there's no reasonable chance of reconciliation. According upon receive that judgment later today, the court will sign the judgment, and at that time, the court will order that the marriage between the parties be dissolved. Judgment shall enter granting a divorce from bonds of matrimony. That will conclude this hearing. You can both zoom out. Thank you again, Mr. Biddle. We'll look forward to receiving that judgment sometime today.
We'll get that to you today, Your Honor. Thank you very much.
Great. Thank you. You can all zoom out. Have a good rest of the day. Good luck to both of you.
Thank you, Your Honor.
You too.
Thank you.
For the record, this matter is before the court for review of plaintiff's motion to modify parenting time subsequent to the parties have engaged in mediation with Mr. Walker. This hearing is being conducted via Zoom. It appears that plaintiff mother Kelly LaVoy is present with her attorney Maria Sikorsky. Also, the defendant Nicholas Alexander is also present. Mr. Alexander, Ms. Spencer no longer represents you. Is that correct?
Not currently. She may in the future.
Yeah. All right. So you're appearing by yourself this morning. Ms. Sikorsky, what did the parties engage in any communication this morning?
Yes, we do have an agreement on the issue of passports. We've agreed that Mr. Alexander is going to cooperate with getting the passports within the next 48 hours, and my client will give him the travel itinerary within 24 hours of booking it. She plans to travel July 14th to the Dominican Republic or a destination like that. So within 24 hours of booking those flights and getting the hotel, she'll provide that information to Mr. Alexander. But with respect to SoberLink and a parenting time schedule and reimbursing my client the cost of the private investigator and modifying parenting time, we had a conversation. We were not able to resolve those issues.
Okay. The court report, Mr. Walker, parties did not appear for mediation at 8:30 this morning as ordered.
They did, Judge. That was me. It was in my calendar for 1:30. I was the one who was late. I had it at the wrong time. And it is in my notes at the wrong time too. My notes from February 13th say 1:30. So I take responsibility for that, Judge.
Okay. So the parties have exhausted discussions about modification of parenting time. Is that correct? How long did they talk this morning? 5 minutes and talk about the passport? Did they talk about parenting time?
Well, I was on the call at 8:30 this morning, and Mr. Walker and I waited until 9, And then he said we should cancel it. And then I was to meet with you at 10:30. And then I guess I went into work. And then it was decided to go ahead.
Understand there's a confusion about the time. Mrs. Zagorski is acknowledging, Mr. Alexander, what the court's trying to determine, have you exhausted all efforts to reach your own agreement? The court can order that the parties reschedule mediation if it's not mediated to any extent or of any significance. This morning, the courts can order that they engage in mediation before the court schedules for another hearing, Ms. Zagorski.
Your Honor, if I may.
Mr. Walker?
The parties did meet with me and we did mediate for approximately an hour before we ended the mediation. I believe from my viewpoint, take it as you want, but from my viewpoint, I believe the parties have exhausted mediation and I do not think it will be able to go any further.
All right, thank you.
You're welcome.
The court was trying to make inquiry about. I didn't know to what extent that they communicated and discussed. First of all, Mr. Alexander, did Mr. Gorski actually state your agreement relative to the screen passport for the children?
I do have a question. She said that I would be getting the passports. I thought I was just signing the consent form for the passports. I just want to clarify that.
I just said you would cooperate.
I know there's a form that I need to sign. I thought that's all I was doing, correct?
Yes.
Okay. Yeah. Yeah. Okay.
So Ms. Lavoie will pay for the cost of the passports, correct? Mr. Alexander simply has to sign a consent form authorizing mom to secure the passports for the children, correct?
Yes, that's correct.
All right. So you'll prepare an order in that regard, Ms. Gorski?
Yes.
Okay. So the remaining issues are parenting time modification, as well as your motion for order to show cause alleging that the defendant father violated the terms of the judgment of divorce by consuming alcohol and transporting the children. Is that correct?
That's correct.
All right. Half-day hearing?
I think that should do it, Judge.
Okay. All right, Mr. Alexander, we're going to set a hearing date today, and Ms. Spencer needs to make this work. The court's not going to adjourn this. That's the problem when you have an attorney, and then they sometimes show up for some hearings and others. She's got to make it work. Otherwise, you can find another attorney. You understand that?
You're saying as far as scheduling?
Yes, we're going to. Mr. Gorski says they're not able to reach agreement regarding the issues of modifying parenting time, as well as the issue of you. It's alleged that you consumed alcohol and transported children. Not that you're intoxicated, simply you consumed alcohol and transported children, which is contrary to the terms of the judgment of divorce. So she's asking that you be held in contempt, either be fined or could be even up to 30 days in jail. So we're going to schedule a hearing date in those merits today. And you've exhausted your discussions about modifying parenting time and resolving the issue of this allegation that you consumed alcohol and transported the children.
I'm sorry, Your Honor. I'm not sure what the question is.
All right. You've exhausted efforts to resolve this with Ms. Lavoie, is that correct?
I don't believe so. I'm trying to resolve it. I'm willing to make concessions on schedule, on limited use of the sober link to prove that I'm not drinking and driving with children. I mean, I feel like I have tried to make concessions and prove things. I personally don't feel like I have exhausted it, but
all right.
I guess I don't really know where to.
Your client feels that the discussions have been exhausted? No middle ground?
Judge, I always hesitate to say that the parties can't resolve it themselves because I'm a proponent of mediation. My client has some real concerns about the children and their safety in Mr. Alexander's care, and he does not believe her concerns are valid, and I don't know what to do with that.
Well, you're asking that the court order that he engage in sober link, correct?
Yes, I'm asking yes, I am, and not just to prevent him from drinking and driving. I think he should be sober during his parenting time. There are concerns, and that raises another issue at a hearing. I don't want to put the 15-year-old on the stand, so I would be asking that this be referred for an investigation regarding parenting time. I know you'll talk to the kids about their preference in chambers, but Mr. Alexander kind of used this as a he said, she said thing, and so I'm going to have to carry my burden of proof, and that means calling witnesses that will support my position. And I don't. I don't know where to go with that when Mr. Alexander will not acknowledge that he should not be drinking during his parenting time.
Well, again, I have said that I would be willing to do the sober link for whatever time that the judge decides needs to be done to prove that I'm not drinking and driving with children. All I asked was that it go both ways because I have the same concern. So I guess it's not that I'm not acknowledging it. I acknowledge that you should not drink and drive with kids in the car. I understand that, and I do not do that. And I'm willing to do it.
Okay, we'll just set for a hearing. So you denied you've ever done that. The court's received a report from a private investigator alleging that presumably that person will testify that he observed you consume alcohol in a driving vehicle. Not that you're intoxicated, but you consumed alcohol. And then you're denying that. So we're going to set it for hearing.
Well, Your Honor, I'm not denying that. What I'm saying is I'm willing to.
Hold on. You deny it or do not deny it?
I do not deny that I've not ever had a beer. I'm denying that I've ever been intoxicated. And
Sir, Mr. Alexander, have you read your judgment of divorce?
I'm sorry?
Have you read your judgment of divorce?
I have, and I fully understand that now. And I
don't think you do. It doesn't say that you cannot drive a vehicle while intoxicated with the children. It says you shall not consume alcohol, then drive.
I understand that, Your Honor. And again, it's something that I have not done since, and it's not something I will do.
Hold on. Since when?
Since the initial issue came up back in August of last year, I guess.
Okay, well,
I mean,
the question is whether or not you consumed alcohol and driven a vehicle with the children after July 3rd of 2023. That's the question.
And my answer to that was I don't recall it, but
all right. Yes, hold on. Let's not waste time. We're going to set it for hearing. Okay, we'll schedule the matter for hearing. May 23rd, Thursday, May 23rd.
I believe that works for me, if that's good with everybody else. May 23rd, is that 8:30 or 1:30, Judge?
8:30.
Okay. I can include this in the order that I submit. And is the court going to refer it on the issue of parenting time or no?
Mr. Walker, do you think it's appropriate to refer the issue of parenting time to the front of the court for formal investigation recommendation?
Your Honor, if you would like that done prior to the
may be helpful
to the order. It may not. If you're looking at the end of May, it may be honestly be tight to get the recommendation done by then.
Right. We're going to set for hearing May 23rd, 8:30. I just I'll refer it. If it gets done, that's fine. If it doesn't, it doesn't.
So May 23rd at 8:30, I can email Ms. Scott and give her both parties' email addresses so that she can get started right away.
That'd be helpful. So
I can let her know that it's on its way too.
Can you include that in your order, Ms. Skorsky?
Yes.
About the passports, mother providing the itinerary to dad, and that the matter is set for an in-person hearing, May 23rd, 8:30, and the issue of parenting time is referred to front of the court for formal investigation recommendation.
Your Honor, will the children be interviewed as well? I just want to make sure Ms. Scott has all the information.
Yes, children old enough to be interviewed by Ms. Scott. So, Mr. Alexander, Mr. Boy, you understand you're putting your children in the middle of this, which is very unfortunate. Children do not want to be put in the middle between two parents that cannot agree upon what's best for them.
That is something that I absolutely.
Now, Mr. Alexander, just maybe listen. Now, Mr. Corsi's not asking that you refrain from drinking while driving. She's saying she wants you to engage in sober link during any of your parenting time to make sure you're not drinking when the children are with you. That's appropriate. And if you can't comply with a simple order to not drive after consuming alcohol with the children in your car, the court's probably inclined to order you engage in sober link. But we're going to allow you to provide some evidence before the court makes a decision. But for a period of time, yeah, you should probably engage in sober link to make sure you're not consuming alcohol while the children are in your possession. So with that, we'll mail out notice. Mr. Alexander, let's make sure we have your address because this notice is going to you, not Mrs. Spencer. You want, and if Ms. Spencer represents you, you need to contact her. Were you aware that Ms. Spencer was not going to appear today, Ms. Sikorsky? Had she informed you that her limited appearance was over?
She did, Your Honor. I sent her a copy of a subpoena and she emailed me and let me know that I should be sending things directly to Mr. Alexander.
Okay. Right, Mr. Alexander, what's your mailing address?
70.
Thank you. That's 12731 West Albany, Petersburg, 49270.
Correct.
Okay. All right. To Ms. Sikorsky, this court despises limited appearances. I never know if an attorney's going to appear or not, but I don't think there's anything the court can do. Would you agree?
Yeah, I think the court rules allow people to bounce in and out. I hate them as much as you do, Judge.
But of course, there's no communication with counsel. I'm not going to, my limited appearance is done. I assumed she was going to attend mediation this morning and appear for this hearing this morning. In any event, Mr. Alexander, we're going to mail you a notice to appear personally, May 23rd, 8:30. You'll be also contacted by the front of the court in the interim for a time recommendation. The court would strongly encourage you to speak with the mother of your children, Ms. Lavoie. The two of you communicate in terms of what's best for your children. You know it's better than the front of the court or even this court. You're asking a stranger to decide what's best for your children. If you can't reach your own agreement, this court will make a decision. And probably not, it'll be one that neither of you like. But that's what happens when the parents cannot agree. Anything further this morning, Ms. Sikorsky?
No, thank you, Your Honor.
All right, anything further, Mr. Alexander? Any other questions?
No, other than, is there any chance for additional mediation or is that done now?
I don't know, Ms. Sikorsky, if you have time this morning, if Mr. Walker has time this morning, I'll leave that to the parties. Front of the court's always available.
I'm happy to talk anytime, Nick. You can email me if Mr. Walker wants to meet with us again for a minute. I'm available to you. I want to get this resolved.
Okay,
I am
well,
available.
It's 11 o'clock. Does everyone have time? I'll be here till noon.
Yeah, we're all here. If there's a way we can do this, Mr. Alexander, I'm happy to listen.
okay.
Mr. Walker, do you have a few more minutes this morning?
I do, Your Honor. I'm available.
Okay. And if you'll put something back in the record, you can zoom back in before noon. Otherwise, we'll mail notice for May 23rd, 8:30.
Okay, thank you, Your Honor.
Okay, we'll put you back in the breakout room, Mr. Alexander.
You were very patient, and I'm glad that everything worked out.
Thank you, Mr. Walker.
Court is recalling Kelly Lavoie versus Nicholas Alexander.
For the record, this matter is back before the court for a Zoom review hearing. The parties wish to continue their discussion and communication regarding modification of parenting time and other relief requested by the plaintiff, Ms. Sikorsky and Ms. Lavoie present, as well as Nicholas Alexander. Mr. Alexander, is it the court's understanding correct that you and Ms. Lavoie have reached an agreement this morning?
Correct, Your Honor.
Ms. Sikorsky, if that is correct, could you state on the record what you understand to be the party's agreement?
Yes, Your Honor, I will, and I'll be submitting an order to this with all of these terms and conditions in it. In addition to the prior agreement that was placed on the record regarding passports and travel, the parties have agreed that my client is going to withdraw her request for a finding of contempt. Mr. Alexander is going to use SoberLink for 4 months only during his parenting time. During his parenting time, he's going to be using SoberLink at 6:30 a.m., 10:30 a.m., 2:30 p.m., 6:30 p.m., and 10:30 p.m. Those results will be emailed to me or my paralegal because we're going to do the cheaper plan where you only get one person who gets the results. We've also agreed that Mr. Alexander is going to reimburse my client for the cost of her private investigator. And as you know, that's $1,300. The parties have agreed to modify their parenting time schedule. Mr. Alexander will have the children every Tuesday and Wednesday overnight and every other Saturday from when he gets off work until Monday to school. And for all of the parenting time, when there is no school, the exchange time will be after work the following day. So for example, he'll take them to school Monday. If there's no school, they stay with him until Monday after work when they'll go back to my client. We're going to reserve, the party started to talk about flipping the Christmas schedule and everybody needs more information. So we're going to reserve that issue for when we come back, and we are asking you for a review hearing after the 4 months. And with respect to the cost of the SoberLink, that will be paid by Mr. Alexander. And if he doesn't have any positive results, if he blows and the results reflect no alcohol, or I'm sorry, if they do reflect alcohol use, he will be responsible for that, period. But he is going to front load the cost of it. If he never blows positive for alcohol, my client will be responsible for the cost. And it may be deducted from the child support, which we are going to determine at the review as well. So that's the agreement. You had ordered that the parties exchange income information, and they did do that. But now we have a new parenting time schedule, and we have the issue of who's going to pay for the sober link. So he's going to pay it up front. And if he doesn't use alcohol, my client pays for it, but we can, maybe give him a credit on child support or something later on to make up for that cost for her. That makes sense.
Thank you. So in other words, Mr. Alexander will receive the credit for 100% of the cost of SoberLink if he tests negative for 4 months.
Correct. That's an easier way to say it, Judge. Thank you.
And the time frame for payment of the $1,300 reimbursement for the private investigator?
We didn't nail that down, Mr. Alexander. How much time do you need?
I'd say at least 30 days. More would be nice.
30 days is fine.
Okay, maybe May 3rd, that's a Friday.
That works.
Okay.
All right, so the $1,300 will be reimbursed by on or before May 3rd, 2024. All right, wonderful. Mr. Alexander, did Mr. Gorski actually state your agreement?
Yes, Your Honor.
I'm sorry, I didn't hear you.
Yes.
Okay, thank you. All right, Mr. Gorski, if you want to warrant to hear Ms. Lavoy regarding the terms of this agreement and her
Yes.
belief as specialist to minor children, please.
Yes, absolutely. Would you please state your name for the record?
Kelly Lavoy.
You participated in mediation this morning,
Yes.
and you heard the agreement that I just placed on the record, correct?
Yes.
You understand it?
Yes.
You're willing to be bound by it?
Yes.
You understand that if I submit an order and the judge enters the order, the previously scheduled hearing for May 23rd will be vacated. And in fact, you and Mr. Alexander will modify your parenting time schedule, and you'll live under the terms of this order. You understand that?
Yes.
And you're asking the court to do that?
Yes.
You understand that ultimately you may be responsible for 100% of the cost of the SoberLink if Mr. Alexander never uses alcohol during his parenting time.
Yes.
Okay. And you believe this all to be in your children's best interests.
Yes.
Do you have any questions of me?
No.
Okay. That's all I have, Your Honor.
Ms. Gorski, of course, the court recognizes that the consent order entered back in July 3rd, and the parties agreed upon that in 2023, that neither party would consume alcohol and drive the children. Prior to today, there was no prohibition about consuming alcohol at home in the presence of the children. And Mr. Alexander's agreed as part of his agreement to not consume alcohol during his parenting time and submit to a SoberLink to verify that. What about Ms. Lavoy?
Your Honor, my client does not drink during her parenting time, and she doesn't mind if there's an order to that effect. However, we don't agree with incurring the cost of SoberLink because there's been no evidence presented that she ever has consumed during her parenting time.
Right. Okay, so you can put in the order then that neither party shall consume alcohol during parenting time, correct? And Mr.
Yes.
Alexander will sign up for SoberLink, and you provide Mr. Alexander with the contact information with SoberLink?
Your Honor, I reached out to Mr. Finley to just confirm that he's still the go-to person, and then I'll connect them via email.
All right, thank you. All right, Mr. Alexander, did Mr. Gorski accurately state your agreement this morning?
Yes.
Okay. And obviously, there's a huge incentive for you to remain absent from alcohol while the children are with you.
You heard the agreement that I just placed on the record, correct?
Yes.
You understand it?
Yes.
You're willing to be bound by it?
Yes.
You understand that if I submit an order and the judge enters the order, the previously scheduled hearing for May 23rd will be vacated. And in fact, you and Mr. Alexander will modify your parenting time schedule, and you'll live under the terms of this order. You understand that?
Yes.
And you're asking the court to do that?
Yes.
You understand that ultimately you may be responsible for 100% of the cost of the SoberLink if Mr. Alexander never uses alcohol during his parenting time.
Yes.
Okay. And you believe this all to be in your children's best interests.
Yes.
Do you have any questions of me?
No.
Okay. That's all I have, Your Honor.
Ms. Gorski, of course, the court recognizes that the consent order entered back in July 3rd, and the parties agreed upon that in 2023, that neither party would consume alcohol and drive the children. Prior to today, there was no prohibition about consuming alcohol at home in the presence of the children. And Mr. Alexander's agreed as part of his agreement to not consume alcohol during his parenting time and submit to a SoberLink to verify that. What about Ms. Lavoy?
Your Honor, My client does not drink during her parenting time, and she doesn't mind if there's an order to that effect. However, we don't agree with incurring the cost of SoberLink because there's been no evidence presented that she ever has consumed during her parenting time.
Right. Okay, so you can put in the order then that neither party shall consume alcohol during parenting time, correct? And Mr.
Yes.
Alexander will sign up for SoberLink, and you provide Mr. Alexander with the contact information with SoberLink?
Your Honor, I reached out to Mr. Finley to just confirm that he's still the go-to person, and then I'll connect them via email.
All right, thank you. All right, Mr. Alexander, did Ms. Zagorski accurately state your agreement this morning?
Yes.
Okay. And obviously there's a huge incentive for you to remain absent from alcohol when the children are with you. Because obviously the SoberLink would terminate after that period of time, correct, Ms. Gorski?
Yes, but the requirement that neither party consume alcohol would not.
Okay. Obviously the children, you understand that, Mr. Alexander, so even though there'd be no required for a SoberLink, there would be a provision order that neither party shall consume alcohol during parenting time. Now, if your children are getting older, they don't need a private investigator. Obviously, a 15 and 8-year-old will know if dad is intoxicated during parenting time or consuming alcohol. So you're aware that provision would continue beyond the 4 months?
Actually, Your Honor, I was not aware of that. I thought that the order was staying in place of not drinking and then driving. Not
that would continue. I guess it's what the two of you agree upon. Obviously, there should not be any operating a vehicle with the children in your possession after having consumed alcohol. But the court understands there may be some family gatherings, Christmas. Ms. Sikorsky, what's your client's intent about things of that nature?
But Judge, my client doesn't drink during her parenting time, and this is the issue: is that Mr. Alexander will not commit to sobriety while he has possession of his children.
Okay, and of course, the court did receive the investigator's report, and in a lot of those occasions, it wasn't Mr. Alexander; he was with family. I think perhaps paternal grandparents, or he perhaps had a drink with dinner. I guess what the court would suggest is this restriction would continue until further order of the court, Mr. Alexander. So if after a period of time you wish to petition the court to modify that you want to be able to consume alcohol during family gatherings, obviously no operation vehicle with the children in your vehicle.
Yeah, Your Honor.
If in fact you want to petition the court for relief from that after a period of time, certainly the fact that you can abstain for 4 months is significant, but the order that's to be prepared, Ms. Sikorsky, is that this restriction will continue to further order of the court. You understand that? You understand that, Mr. Alexander?
I'm sorry. I was under the impression that the current order would stay in place, that the SoberLink was, for the next 4 months. I'm good with the current order staying in place, I guess is what I'm saying.
But Mr. Alexander, you raised the issue when you accused my client of drinking during her parenting time.
I have no problem with her drinking during parenting time. The issue was drinking and driving during parenting time.
And of course, you agreed to that, Mr. Alexander. I mean, you agreed to that. Once some of this court ordered, you agreed to that back in July of 2023. You got to acknowledge that.
Yes, I did, and I continue to agree to that.
Okay. Well, the court's feeling of the matter is, and if you want to withdraw from this agreement, that's fine. The court's opinion is that prohibition against no consumption during parenting time will continue until further order of the court, which means you have to petition the court. Let some time pass. And obviously the court understands sometimes, when you got a family gathering, you should be able to have a beer, a glass of wine, provided there's no operation. But that would have to be something that you and Ms. LaVoy would have to discuss. And that would have to be, you'd have to petition the court for relief from that. So the order would provide no consumption of alcohol during parenting time for either one of you, and that will continue until further order of the court.
Your Honor, would I be able to petition that at the the follow-up hearing after what we were scheduling in August or whatever?
The court's opinion is that you would be permitted to petition the court, and we would have that discussion once again. Mr. Gorski, any objection to that?
No,
Okay. And Ms. Gorski, you're suggesting review date to when? And sometime like in August?
yes, maybe get everything nailed down before the kids go back to school and after the 4 months has passed with SoberLink.
So yeah, we're looking at some dates in August 1st and August 6th. Mr. Alexander, so yes, this restriction will continue until then, and that could be discussed at the time of the review.
Plans in August.
August 6th is fine with my calendar, Your Honor.
Okay. We have either 8:30 or 1:30, Ms. Sikorsky.
You have a preference, 8:30 or 1:30? I defer to Mr. Alexander. What's more convenient for you, sir?
What day of the week was that?
It's a Tuesday.
Tuesday, August 6th, and it'll be put in the order. We either have a time slot of 8:30 or 1:30. What's best with your schedule, Mr. Alexander?
1:30 would work best for me.
All right. So August 6th at 1:30, that'll be a review of any outstanding issues, whether it's modification of parenting time, school issues, or the alcohol consumption, Mr. Alexander. But you just think about it. I mean, obviously, time with the children is when you're focused on them.
I understand that, Your Honor.
But the court again, so you'd have to bring that to attention in court on August 6th when you come back. But until then, the order would provide that until further order of the court, neither party shall consume alcohol while the children are in their possession. Understood?
Yes.
Understood.
Okay. Mr. Alexander, do you have any questions for the court or any questions for Mr. Gorski?
Not at this time, Your Honor.
Right, Mr. Gorski, do you have any questions, Mr. Alexander?
No, thank you, Your Honor.
Right. The court would like to thank Mr. Walker for his continued assistance, and the court would applaud you, Ms. Lavoie and Mr. Alexander, for reaching your own agreement. It may not be what either of you fully likes, but again, the children will be on their own before you know it. This is time to focus on the children, their best interests. And yes, obviously, there's no indication that you put the children in danger, Mr. Alexander, back then, but you agreed to it back in July to not have a beer at a family gathering for dinner with the grandparents, but you agreed that you would not drive.
Yeah, I will be honest, Your Honor. I somewhat misunderstood that, and to be honest, I kind of agree to that to finish things up and stop wasting the court's time and our time and money. But I do understand that now.
Okay, and the court be inclined to continue that, no driving with the children after consuming alcohol. So another thing about if you're having family gathering and you wish to have a drink at home while the children are there, like for Christmas or Thanksgiving, but surely neither one of you should be driving with the children after consumed alcohol. So that I will assure you that would continue. However, we will address whether or not you can have alcohol during your parenting time when we come back on August 6th at 1:30. But these restrictions will continue until further order of the court. There's no guarantee of that. I'm just giving you the court's thoughts. Mr. Zagorski, you'll reduce all this to writing.
Yes.
Will you send it to Mr. Alexander for his review and approval, or submit them a 7-day rule? How do you intend to submit this order?
I can send it to Mr. Alexander for his review.
All right.
And then if we get hung up, I can always 7-day it, but I can send it to him as a courtesy.
Okay, Mr. Alexander has an email address you have, is that correct?
I do have his email address, yes.
Right, so Mr. Alexander, can he e-sign that? Do you have the capability they can e-sign the order?
Oh, e-sign? Yes, I believe so, Your Honor. Yes.
Right, so Mr. Alexander, Mrs. Gorski reduce all this to writing, put in the proposed order, she can email it to you for your review. If you have some questions, call Mrs. Gorski first. If you cannot agree upon language in the order, then she'll submit that under the 7-day rule, which she provides you notice that you have to file a written objection and the court would schedule a hearing before entering the order. Any other questions, Mr. Alexander?
No, Your Honor.
Again, thank you, Ms. Skorsky, for the time this morning. Again, a court would applaud you, Mr. Alexander, and Ms. Lavoy. No need to have the children interviewed by the front of the court or this court. So with that, we can conclude this matter. You can all zoom out.
Thank you, Judge, and thank you to Mr. Walker and everybody's patience for my scheduling snafu. I apologize.
Thank you.
Josh, there's
Thank you.
actually a disagreement that we've been emailing about since we left.
I'm sorry, do you need to go back into breakout room, Mr. Goldman?
I think that would be prudent, Your Honor.
That's fine. Okay, Mr. Walker, still appears to still be available. That's totally fine. For the record, this matter is before the court for a continued pretrial conference subsequent to mediation. This hearing is being conducted via Zoom with present Attorney Alex Bowman representing the plaintiff, Jennifer Hurley, and Ms. Hurley is present. In addition, Attorney Cassandra Suter is present representing the defendant Jeffrey Hurley, and Mr. Hurley is also present. Good afternoon, everyone.
Good afternoon.
The court has been informed, Mr. Walker, the parties have in fact reached their own agreement. Is that correct, Mr. Goldman?
Yes, Your Honor.
Like, who would like to place agreement on the record?
I can do it unless Cassandra would like to.
Go ahead. The floor is yours.
Okay, Mr. Goldman, please.
Defendant will pay plaintiff $1,000 for property settlement. That will be paid out in $200 increments every week for 5 weeks. Plaintiff is awarded the mobile home free and clear. She will refinance that home in her name and make a good faith effort to do so as soon as possible, but it must occur within 6 months. If she misses any payments during that period, she will hold defendant harmless. Plaintiff is also awarded an iPhone and an iPad that are currently in defendant's possession, and each party will keep the debt in their own name. I think that's it.
And just to think that their vehicles that are currently in their position are to be held individually and keep each other held harmless.
Correct.
The plaintiff is currently residing in the mobile home in question. Is that correct?
That is correct.
Yes, Your Honor.
So she will pay the lot rent as it comes due and maintain insurance on the same?
Yes.
Yes.
What if she is unable to refinance? Will the home then be sold?
No.
I think that would be the assumption, if that's the whole 6 months requirement, Jennifer.
It won't be
Ms.
sold.
Suter? I'm sorry, if it's not refinanced within 6 months, it would be sold, is that correct?
We hadn't discussed that explicitly. I think it's implicit.
No.
Okay, do we have an issue that needs to be further discussed?
I would just request to be put in a breakout room with my client.
Again, hopefully it can be, but obviously sometimes the financing market for mobile homes is entirely different than real estate market.
Understood, Your Honor.
Right, I'll put you back into a breakout room.
Thank
I
you.
don't know if Mr. Walker is still available.
I don't know if we need Mr. Walker. I think I just need to speak with my client.
Okay,
You can rejoin breakout room 1.
If plaintiff is unable to refinance the home within 6 months, in that event, it would be sold.
is that agreeable, Ms. Suter?
Yes.
Okay, and hopefully that can be refinanced. Very well. With that clarification, Ms. Suter, as Mr. Goldman accurately stated your client's agreement. Thank you. All right, Mr. Goldman, if you want to begin with Ms. Hurley, please.
Yes, Your Honor. Jennifer, please state your full name for the record.
Jennifer Lynn Hurley.
And did we file for divorce earlier this year?
Yes.
Or sorry, last year?
Yes.
At the time that we filed, had you lived in Michigan for 6 months?
Yes.
Had you lived in Monroe County for 10 days?
Yes.
Was everything that we put in the complaint for divorce true at the time we filed it?
Yes.
Is it still true today?
Yes.
And there are no minor children between you and Mr. Hurley, correct?
No.
And do you agree that your marriage has broken down if there's no possibility of reconciliation?
No reconciliation.
Is there any possibility that you may be pregnant today?
No.
And you are not seeking spousal support, correct?
No.
And do you understand that by not seeking it now, you can never ask for it in the future?
Yes.
Do do you understand that we could have gone to trial on all these issues that we negotiated over today?
Yes.
And that by reaching this agreement, you are waiving your right to trial?
Yes.
Nothing further, Your Honor.
Thank you, Mr. Goldman. Is Ms. Hurley still receiving public assistance?
Say that again?
Maybe it's not relevant if in fact Ms. Hurley continues to be eligible for legal services, then the court would not order to pay the filing fee. We can perhaps address that to Mr. Hurley. Ms. Suter, do you have any questions, first of all, for Mr. Hurley?
I do not, Your Honor.
Any questions for Mr. Hurley? And one thing the court wants to address before we finish, that is payment of a filing fee that was previously suspended and waived as to Ms. Hurley because she was on public assistance or otherwise qualified for legal services.
So Jeff, are you receiving public assistance at this moment in time?
No, I'm not.
The filing fee is $175, and it doesn't appear there's really assets to pay that out of. There's no bank accounts, correct?
We're not dividing the bank accounts currently.
Okay. Well, the court would be inclined to order Mr. Hurley to pay the $175 filing fee, and I'll give as much time as he needs. If he needs a month or 2 months, that language needs to be addressed in judgment of divorce.
Okay, we will do that.
Mr. Hurley, how many? There's $175 fine fee due to the Monroe County Clerk. You can pay that in cash, or you can pay by credit card, but you're going to charge a 3% fee by paying for a credit card. You're better off paying in cash. You have to pay one lump sum. They will not take installment payments. How much time do you need with which pay $175?
I have to the end of April.
I'm sorry, end of April?
Yeah.
All right. So, Mr. Goldman, you put in the judgment of divorce, and Mr. Hurley will pay a $175 fine fee to Monroe County Clerk on for April 30th. 2024. Mr. Hurley, if the dog eats your check and you are laid off or injured, you call the court and I'll give you an additional couple months. I will give as much time as you just don't blow it off. We blow it off, that's when bench warrants issues. We don't want to go there. So $175 fine fee, Monroe County Clerk on for April 30th. Thank you for addressing that, Ms. Suter. Mr. Goldman, if you could serve just one paragraph in the judgment, providing for that, I would appreciate that.
Very good.
Okay, Ms. Suter, you can continue.
Oh, I have no further questions for my client.
Do you want to verify with Mr. Hurley his understanding of the terms of the settlement, that he's agreeable to all of it?
Yes, Jeff Hurley.
Yes.
So I'm just going to ask you a few questions right now. Today, we were in mediation with Mr. Walker and we placed the agreement on the record. Alex Goldman did so. Did you understand everything in the record and did you hear it in via Zoom today?
Yes.
Okay, thank you.
Thank you.
Mr. Goldman, do you have any questions, Mr. Hurley?
No, Your Honor.
And you have further judgment, Mr. Goldman?
Yes, Your Honor.
Very well, the court would like to thank and acknowledge Mr. Walker for his assistance, as well as, of course, attorneys Goldman and Tudor for helping facilitate amicable resolution in this matter. One last question. Mr. Hurley requesting restoration of former name.
Jennifer, do you want your maiden name back?
I want I have a mom that's adopting me. Reichard, Reichard.
Thank you. You can also include that in the judgment to Mr. Goldman.
Of course, Your Honor.
Very well. Once again, the court would like to thank Mr. Goldman and Mr. Suter for helping facilitate resolution. The court would applaud you, Ms. Hurley. Without question, the best resolution is one which you both participate as you have. Based on the testimony that's been presented this afternoon, as well as claim filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Calling upon receiving consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter granting a divorce from bonds matrimony. Now, concludes, you can both able to zoom out. Have a good rest of the day, and good luck to you, Mr. Hurley.
Thank you.
Thank you, Your Honor.
Welcome. You're welcome.